Dave Hansen is the executive director of the Authors Alliance. He also was previously working in a similar capacity to Rachel in a library, helping researchers with their access and use of library materials. And now he's the executive director of the Authors Alliance, an organization that represents the interests of academic authors within copyright and other policy debates. And he was previously responsible for Duke University's libraries, core research collections, and scholarly communications.
So as Rachel teed up, I'm going to talk through some responses and some potential pathways forward, both for the 1201 process and advancing on kind of where we are there, because the exemption that we have is a pretty incredible advancement in terms of access for text and data mining research, but it still has quite a few hoops to jump through. And so there are some interesting developments there to talk about. And then I'll get into some of the ideas on how we can address contractual limitation. So first, on section 1201, 1201 starts from this basis that restrictions on access based on technological protection measures like DRM are permissible, and that you have to go seek special exceptions to circumvent those. And that's the structure of the law. That's the process that Eric talked through, where you have to basically go petition the government to give you special rights to circumvent those restrictions. And so one of the real challenges with that kind of approach is that the right that you're trying to exercise in circumventing those technological protection measures is a pretty fundamental right. Fair use is codified in the Copyright Act, Section 107 of the Copyright Act, but it's something that has long existed before its codification. It's been embedded as part of U.S. law for a very long time, is viewed as a particularly fundamental right, and so much so that the Supreme Court has talked about it in several instances as embodying the First Amendment protections that allow us in the US to exercise our free speech, free expression rights. And so one of the potential pathways for opening up access for researchers to do more and easier text and data mining in the United States is actually a kind of facial attack on the entirety of the 1201 exemption process. Challenging the idea that in order to exercise your fair use rights, you have to go seek special government approval to be able to do that. And up here on the screen, on the slide, you can see a couple of quotes from the Supreme Court about how fair use is really intertwined very closely with the First Amendment. And so this is that would be a pretty radical change for current US law, but it's one that's actually being tested right now. In the next slide, I have just a screenshot of a case that the Electronic Frontier Foundation has brought, Green versus the United States Department of Justice. And it's challenging exactly this. And the basis of the suit is for the First Amendment. So what EFF Green is arguing in this case is that pre-existing limitations on the exercise of fair use are impermissible because exercising fair use is tantamount to exercising your First Amendment rights. There was another suit brought, I guess it was about 15 years ago, Corley, where a very similar argument was raised and rejected in the Second Circuit. But a few things have happened since then, including those quotes that I just had up on the screen of the Supreme Court saying in multiple instances that fair use is so closely intertwined with the First Amendment, meriting, possibly a closer look at this. Even aside from that, there are other pathways for expanding access within that 1201 process. So as Eric talked about, that is a process that happens every 3 years. And there's an opportunity both to ask the government to maintain the current exemption and to expand on it if that is merited, and there's good evidence to support that. And so that's another potential pathway for addressing that sort of copyright adjacent limitation on exercise of text and data mining. So to understand contractual override, it's helpful, I think, to talk a little bit about politics and the structure of US law. So there are a whole bunch of ways to address this issue that publishers, licensors are layering on additional restrictions that go beyond what the Copyright Act allows for. One way to do that is to go and to ask Congress to amend the law and say you can't do that. And the politics part of this is that is not really a realistic option in most people's minds at this point. So there are other options, and the other options really lie at the state level. You know, in the US, we have this kind of complicated patchwork of state regulation over all sorts of consumer transactions. And so there have been some efforts to address transactions and even library transactions with the purchase of electronic material at the state level through state law. So what I have up on the screen here is a kind of orthogonal effort to address a very persistent issue with ebook licensing. The crux of it is that for a lot of ebook publishers, they are either unwilling to deal with selling or licensing copies of their works to libraries, or when they do, they place extraordinarily high prices on those works with extraordinarily high barriers to actually using them. And so there's an effort afoot in a number of states to develop legislation to address these issues. So I raise this because it's a pretty close analog to what you could imagine states doing to protect the rights of text and data mining researchers, or just generally the rights of the public to exercise their fair use rights. So in Maryland, there was a lawsuit, and what they said is, Maryland, you can't do this. And the reason you can't do this is because federal copyright law preempts state law. Section 301 of the Copyright Act says that basically federal copyright law provides the exclusive set of rights and protections under copyright, and state laws that provide to the contrary are preempted. And so this was a problematic case for this kind of strategy, to have states step in and say, well, copyright law aside, you can't use contracts in our state to do these impermissible things. The Maryland case, though, is a little bit different than I think what we would see in a situation where you know, states might be able to go in and provide some real protections for text and data mining, because one of the things that the Maryland bill did that was really the big problem in this lawsuit, and why they lost the lawsuit, was they had this shall license language. And they told publishers, you must license to libraries on reasonable terms, and then they included some explanation of what that meant. And one of the real problems with that is that we know under the federal law that Congress knows very well how to set up a compulsory licensing system if they want to. And Congress has not done that for the case of the situation of libraries, nor has it done that for text and data mining research uses. And so one of the challenges at the state level is, how do you address this issue without forcing publishers or other rights holders to license? This is a letter response from the U.S. Copyright Office responding to a request from Senator Tom Tillis, asking about the office's input and opinion on copyright preemption in the case of the Maryland law. And what was really interesting about this response was it actually left a pretty good amount of room for states to do some consumer protection regulation while not stepping over that line into contract preemption. And so the conclusion of this letter was that the Maryland law would likely to be found preempted because it had this must license language in it. But efforts that stop short of that may be permissible. So I showed that slide before with the map. That was put together by a group called Library Futures, which has been voting legislation to address the library licensing issues. one of the things that they've highlighted in these other states is that they've taken a different approach, where they have proposed laws that don't say that you have to license. What they say is, to the extent that you do use our state contract law, we're going to make certain terms unenforceable as void for public policy. So just like Rachel mentioned, you can't sign a contract that says that we're going to go murder somebody because that's illegal. It's perfectly within the ambit of state contract law to say there are certain things that are unconscionable and that we're not going to allow you to make agreements to do. And one of those things reasonably could be, particularly given that fair use has a strong First Amendment connection, is states going in and saying, we're not going to allow you to restrict consumers' rights to exercise their First Amendment and fair use rights. This kind of sums up this pathway. It basically addresses the kind of quirk in US law that we have this federal system of copyright under which almost all of the rights are licensed under contracts that are governed by state law. And so it really leverages that interesting little quirk. I'll conclude by giving a shout out to Catherine Crump, who is Eric's colleague at the Samuelson Clinic and wrote this really great piece on the different pathways to dealing with these contractual override issues. And so she kind of highlights in this piece some of the basic challenges, but also some of the potential pathways forward, the option of trying to get Congress to do something, the pathway of trying to get states to do something. And also, I think one of the issues that we face is that this is not something that the Copyright Office or the 1201 process can really deal with. And I think that's important to highlight, as critical as that 1201 process is to gain exemptions from restrictions on breaking DRM and technological protection measures. The Copyright Office can't go in and just say, oh, and also all these contracts are invalid. They don't have that authority. And so there really has to be another avenue for solving those issues.
Thank you, everybody. That was terrific. Rachel, Dave, Eric, thank you very much. And I think that gives us an entry into some interesting discussion to have from here.